Good afternoon, everyone. My name is Carrie Filiberto, and I'm the Deputy Executive Director of ConsensusDocs. Thank you for participating in today's 90-minute webinar. Today, you will learn about the differences between the ConsensusDocs 200 and the AIA A201. A few housekeeping items, a copy of the PowerPoint presentation, and a link to the recording will be emailed to you after the webinar. You will have an opportunity to ask questions of our speakers. Please type your questions in the questions box, and we'll have the speakers address them at the end of the presentation. I would now like to introduce our esteemed speakers, Stan Dobrowski, Mark Groff, Robbie MacPherson, and Alec Moseley. Stan Dobrowski is a senior counsel in the Columbus office of Calfee, Halter, and Griswold, LLP. His practice is concentrated in construction law, public law, and finance. He is a former chairman of Division 12, Owners and Lenders, of the ABA's Forum on the Construction Industry, and a member of the ABA's Construction Litigation Committee, as well as a former chairman of the Ohio State Bar Association's Construction and Government Contracts Committee and the Columbus Bar Association's Construction Law Committee. He is also a member of the law group of the Builders Exchange of Central Ohio. As a former Assistant Attorney General, Stan represented several state entities and helped draft the state's standard construction contract documents and resolve construction claims in mediation, arbitration, and litigation. He provides representation to local governments, developers, contractors, and design professionals for construction matters. Stan has his BA from the University of Notre Dame and his JD degree from The Ohio State University. He regularly speaks to groups of lawyers and non-lawyers, has written numerous articles on topics of interest to persons involved with the construction and with state and local governments, and he authors the Open Meetings and Public Records chapter of Ohio Municipal Law. Mark Groff is a senior counsel in the Washington, D.C. offices of the international law firm of Aiken, Gump, Strauss, Hauer, and Feld, LLP. His practice is devoted to representing parties in the construction and government contract industry. Mr. Groff is an adjunct professor at the University of Maryland, Department of Civil and Environmental Engineering Project Management Program, where he teaches graduate courses on the legal aspects of project management and design, engineering, and construction. He is a co-author of Construction Scheduling, Preparation, Liability, and Claims, with the third edition being published in 2010, and he is a graduate of Hofstra University and the George Washington University Law School. Robbie MacPherson is the Director of Business and Commercial Litigation at Gibbons Law, PC. He is a Fellow of the American College of Construction Lawyers and former chair of the ABA Forum on the Construction Industry. He has been practicing construction law since 1981, focusing his practice on drafting and negotiating all manner of contracts relating to construction projects and resolution through negotiation, mediation, arbitration, and litigation of construction disputes. He is admitted to practice in the state and federal court of New Jersey and New York. Robbie regularly acts as construction contract and disputes counsel for contractors, subcontractors, suppliers, and owners involved in building and heavy civil construction for public and private work. He currently teaches construction law and previously taught alternative dispute resolution at Rutgers Law School. Alec Moseley received his BA degree from the University of the South and his JD from the University of Alabama, and he is a member of Hand Arundel, LLC, practicing in its Mobile, Alabama office. He chairs his firm's commercial litigation practice group and construction and public contracts practice team. His primary areas of practice involve construction and complex business litigation and dispute resolution and negotiation of construction and design agreements. He is also an arbitrator member of the American Arbitration Association's roster of neutrals. He is a member of the ABA's Forum on the Construction Industry and Litigation and Public Contract section, and has served as the Forum Chair of Division 2, as a member of the Governing Committee, and as Chair of the Publications Committee. He is a Fellow of the American College of Construction Lawyers and an Associate Editor of the ACCL Journal. He is also a member of the Associated General Contractors of America and of its Contract Documents Committee. Mr. Moseley is listed in the Best Lawyers in America in the fields of construction law and construction litigation. He frequently writes and speaks on matters of interest to the construction and design industries. Well, we're very lucky to have such prominent construction industry attorneys for our presentation today, and I would now like to turn over the presentation to them.
Thank you, Carrie. The first topic we will discuss today is the right of the constructor or contractor to have information about the owner's source of financing for the work. And I'll speak about the ConsensusDocs 200 particularly. In this market and in this industry today, financial information is obviously more critical than ever. But it's always been crucial for constructors to have information about payment, because at any time, construction is a credit business where performance it gets in advance of payment by at least a month or more, and where a percentage of the value of work that's delivered is withheld often for many months. In many states, the constructor is effectively required to advance payments to its subcontractors and suppliers, regardless of payment from the owner, by operation of the Prompt Payment Acts or by negation of pay if paid clauses. Moreover, where payment bonds exist and the contractor indemnifies the surety, in effect, the contractor will often be obliged to make payment to subcontractors and suppliers independent of its collection of funds from its owner. Both ConsensusDocs 200 and AIA A201 deal with this subject. The ConsensusDocs treatment is found in section 4.2, which contains a very simple statement that the constructor is entitled, prior to commencing the work and thereafter when it makes a written request for it, to information about the owner's financing of the project. The contractor need not commence or continue performing the work unless it receives this information. The information cannot be altered without notification to the constructor later, once it's been furnished to the constructor by the owner. And if a request is made and not honored by the owner, the constructor has the right to terminate under section 11.5.1 after giving 11.5.2 after giving proper notice. Obviously, constructors should not abuse this privilege, and in my opinion, they should be willing to agree to any reasonable non-disclosure agreement that an owner or its lender might insist upon. But this does provide the constructor with a right to obtain this critical information, which it requires to ensure that it will be paid for its work.
The AIA A201 concept on this is based on the assumption that very early in the negotiations, the contractor will have requested and obtained from the owner it plans to build for information about the owner's finances and the owner's ability to undertake the project that it intends to hire the contractor for. And in that vein, the document provides that prior to the contractor actually commencing work, the contractor can request evidence that the owner has made the financial arrangements that will allow the owner to pay the contract costs. And it very clearly provides that the owner may not materially change those arrangements once they are disclosed to the contractor. Now, while the AIA does not define exactly what the owner must disclose to the contractor, the fact is that on most projects that will be evidence of a construction loan sufficient to pay the cost of construction. The contractor clearly at that point in time and surely thereafter will know who the lender is and will most likely have had a lot of dealings with the lender, because the lender on most projects is going to require the contractor to enter into an agreement providing that the lender can take an assignment of the owner contract in the event of an owner default. And so therefore there's going to be communications between the contractor and the lender. Once the contractor starts work, the contractor is not precluded from getting updated information, and in fact can get updated information provided there's a reason to get that information. But the reasons are fairly liberal. If payments are not being made timely, if there are material changes in the work. This again goes back to the lender. Most of these lender contingent assignment agreements are going to provide that if there is a material change in the work, that the contractor notify the lender. The contingent assignment might also provide that the contractor notify the lender of any change orders over a certain dollar amount. The AIA documents also allow the contractor to request additional financial information if that contractor has a, quote, reasonable concern. That's a fairly broad standard and should be easy to meet. The reality is that both of these clauses are substantially similar. The consensus docs tips a little bit to the contractor. The AIA tips a little bit to the owner, but I don't think either party is any significant disadvantage. The reality is that if the parties deal with each other in good faith and confront financial problems as they arise and deal with them head on, the language is going to be irrelevant. If things go bad financially and folks hunker down, even the best language is not going to help them.
Well, I would just say, Robbie, that I think the language certainly used to be quite similar. In the AIA A201 of 1997, the provision on owner providing financial information was essentially identical to what is now in the ConsensusDocs 200, but the AIA was evidently compelled by owner complaints to retreat from that to what is now a rather weak provision, and one which I think is a recipe for disputes. The one free look at owner financing under the AIA document must come prior to commencement of the work. And given the breadth of the definition of the work, if the contractor does almost anything prior to requesting this information, it will have waived its only guaranteed right to receive it. Its later rights to supplement that information are either come too late, as in the example where a payment has, or at least one payment has been missed, and the contractor by then will have probably provided 5 or 6 weeks worth of free work before it realizes the owner has no financing. Or the provisions are too subjective and ambiguous. For example, where there's been a change in the work, and we all know that owners and contractors frequently disagree about whether there has been a change in the work, or when there's reasonable evidence of a concern about the owner's finances. It is certainly conceivable, and frankly I think almost inevitable, that a contractor and an owner would have different views about what a reasonable concern is. I think that if properly used, and I frankly haven't heard any data about misuse of it, the objective standards of the ConsensusDocs 200 are superior to those subjective provisions of the AIA A201.
Okay, I want to talk a little bit now about the submittal schedules and the project schedules in the two documents. First, the submittal schedule. Unlike the AIA, ConsensusDocs 200, it contemplates one project schedule, which would include the constructor's submittal dates in it. And under 200, the constructor delivers the submittal in a manner consistent with the schedule of the work, the project schedule, so as not to delay the project. As most standard contracts provide, the ConsensusDocs provides that if the constructor is proposing a change or a substitution from the contract requirements, that must be specifically identified in the submittals, and the owner must specifically authorize such change or substitution. In an effort to be fair and balanced, the consensus documents go further, though, than the AIA and specifically state that neither the owner nor the design professional may make changes through the submittal process without specifically identifying and authorizing those deviations. So the consensus documents, therefore, they address and provide the constructor relief for situations which sometimes occur on troubled projects where the design professional attempts to correct design defects in the submittal process without going through the formal change process. That provision 3.14.1 gives the contractor some relief. In addition, under the submittal schedule provisions of 200, the owner is responsible to review and reasonably promptly review the submittals and act upon them reasonably promptly so as not to cause delay on the project.
The A201 from the AIA certainly calls for two schedules, and that's something that people have to pay attention to. because not only do you have to produce a separate submittal schedule and a project schedule, but they're supposed to be coordinated with one another. Indeed, the document specifically calls for that. The submittal schedule itself must be transmitted to the architect and reviewed and approved by the architect. And that approval is to not be unreasonably delayed so as to not delay the project. This, I think, points up one of the issues, one of the prime issues between ConsensusDocs generally and the AIA documents is the primacy of the role of the architect in the AIA documents. We can question whether that's appropriate or not in any given case, but I don't think that it can be completely ignored and needs to be addressed appropriately. The ConsensusDocs clearly takes the view that owners should be active, and that certainly makes sense, but in many instances, the owners simply aren't capable of providing the level of activity, involvement, knowledge, experience that may be called for. So I think one of the things we have to remember as we go through this process today is that there is that fundamental difference between the documents. Having said that, the submittal schedule, unlike ConsensusDocs, does not have any sort of set period for the architect's approval. It's not, indeed, the approval is not even necessarily tied to the project schedule. There is no separate approval by the owner, which again raises the question of whether that is really the fully appropriate role for the architect in all cases. Now, if no submittal schedule is provided, if it's overlooked or there's a failure to provide it or to timely provide it, there is a penalty provision in the AIA documents in section 3.10.2 in that the contractor is unable to obtain any relief for cost increase or time extension based on any delay in the review of a submittal once it is approved, or sorry, of the submittal schedule once it is submitted and approved. As a practical matter, this means that until that precondition is met, contractors may not seek increases or extensions related to submittal items or the review of those submittals. Clearly a hammer instead of a carrot approach here by the AIA. As mentioned, once something is in fact submitted, the review is to be performed in accordance with the submittal schedule. If we have something that's not on the schedule, then a reasonable time for review is provided to the architect. Again, no set time. Now, architects will sometimes argue that they cannot be bound by set times because they have higher obligations to assure that there are no health and safety items. And as a result, in part because those health and safety concerns are addressed in their licensing requirements, they need to be able to take as much time as is needed to assure that submittals, shop drawings, samples, and the like are properly reviewed so that they don't create a problem on the project simply because of a rushed review. Obviously, no one wants another Kansas City Hyatt situation simply because some architect didn't get around to fully reviewing something. On the other hand, to be fair, I think one has to take some of that with a grain of salt. The timeliness of reviews is a sticking point both for contractors and owners, and it would be nice to see some attempt to give the architects some limits for their review. Ultimately, the submissions are to be in accordance with the submittal schedule or to be done reasonably promptly. Again, if there's something that crops up that's not on the schedule, Presumably you can amend the schedule, although there is no provision in the contract that expressly addresses that. But I think the primary differences between the consensus docs and the AIA approaches here are the factors that relate to the idea that the architect has a much higher role and perhaps the only real role, as opposed to having the owner get involved in any sort of review of submittals.
With regard to the project schedule, as we said, the consensus documents require one schedule that must show the plan dates, including the dates on which the information approvals from the owner are required. That has to be right in the project schedule, and that must be submitted before the first pay app. And importantly, 200 contemplates owner approval of the schedule. A written approval is important, as many owners are reluctant to approve schedules, which can cause many problems later on if there are delays in the project. Without an approved schedule, it makes it more difficult to analyze who's responsible for project delays if there's no approved baseline from which to compare as-built performance data. Constructor, under the Consensus Docs 200, it must comply with the schedule upon the owner's written approval unless otherwise directed by the owner, or unless they are otherwise entitled to a contract time adjustment under the provisions of the document. And under the consensus documents, it also provides under Set 621 that the constructor is to update the schedule monthly or at appropriate intervals. Again, updating the schedule is important if the schedule is going to remain a viable planning tool or a tool to later analyze project delays should issues come up with regard to that. Finally, in this last bullet on the slide before us, I think the consensus documents do a good job addressing head-on a situation when it often occurs. The owner requires changes to the constructor's work sequence. 200 specifically addresses that and says that the owner can require such changes as long as they are reasonable. And it also specifically states that if such changes cause an increase in cost or time, the constructor is entitled to an equitable adjustment. So that takes care of the situation where the owner may, through some direction, cause a change in the sequence of the constructor, and which increases cost and time.
On the AIA A201, there are some differences in approach, but all in all, I think that anyone looking carefully at the document will agree that the provisions are somewhat minimal. As a consequence, the first question that one has to face when addressing the A201 in this context is, do we need a more detailed scheduling specification to more clearly lay out what are the expectations with regard to the schedule? Another point that Mark touched on is that the AIA document calls for the contractor to submit the construction schedule for owner and architect information and not approval. And that may be a fine point, but there is some notion in the case law that there is a functional distinction between information and approval. Approval seems to be taken to mean, at least in some contexts, that the owner has taken control of and perhaps ownership of the schedule to the extent that any deviation from the schedule is more likely than not to be viewed as something for which the owner bears responsibility and will have to provide compensation and extension. Whereas some cases suggest that if the owner merely accepts a schedule for its own information, the schedule itself remains within the control of the contractor. It remains the contractor's schedule, and questions about deviations from the schedule become a bit more involved as to what are the consequences of the deviations. Depending on where you sit in the process, I think you can make a reasonable case for either approach. The AIA does not provide a specific time frame for preparation of the schedule. It merely provides that the schedule shall be provided promptly after contract award. Anyone who's worked on a schedule or on a project where everyone is looking to get started, get moving, get the project rolling, maybe already under some time constraints, may find that's not particularly helpful language in terms of getting everybody on the same page and rolling, or even in coordinating schedules. Once the schedule is prepared or is being prepared, the contractor is to take account, however, of certain items that the 201 does list. Amongst those are obvious contract time limits, the most obvious being, of course, substantial completion, but there may be other milestones, particularly in an industrial setting. There may be milestones with regard to mechanical or operational testing and the like, and those have to be addressed. I think from the owner's standpoint, that makes a lot of sense. The contractors, one would presume, would also like to have a clear idea of when actions are to be taken by themselves, but we also have to remember that both the architects and the owners' activities and approvals and the like need to be factored into these schedules as well. The AIA goes on to say that the schedule is to be revised as needed. This is clearly an attempt to provide for a continuing duty to update the schedule, and that, of course, is not only useful from a claim standpoint, it's certainly necessary if the schedule is in fact going to be used to manage the project or to help administer the project. Unfortunately, however, the AIA does not specify how often that updating should occur, and of course that can be quite problematical when you're trying to plan if the schedule hasn't been updated recently to take account of events that have occurred on the ground in the schedule. The schedule is to be related to the entire project, so the notion is that the construction schedule should deal not with any one contractor's or subcontractor's area necessarily. It certainly can do that as part of the overall whole, but the idea is to look to getting the entirety of the project done. And again, I would point out that what seems to be inherent in that is that although the contractor is preparing the schedule, there needs to be some account taken of activities to be performed by the architect, the owner, and other people who may be involved in the projects, perhaps governmental authorities and the like. As a consequence, partial schedules are really not envisioned here, and while those certainly can be useful for a number of purposes, both in terms of operating the schedule or certainly in pursuing delay claims, there's no provision here to address them specifically. The schedule ultimately is, according to the A201, to provide for the expeditious and practicable execution of the work. And this, of course, is a nod to the idea that what the schedule should be primarily used for is getting the project completed. Whereas, of course, in many cases, the schedule provides a significant function in delay claims. There is a statement in the A201 that the contractor, and presumably everyone else, is to perform in accordance with the most recent schedule. Well, the notion of a most recent schedule, again, harks back to the idea that the schedule is to be timely updated, but if you don't know when updates are coming out or what period the updates will cover, it can be a little bit difficult to try to forecast and use that kind of schedule for planning. So again, it would be nice if we had some clarity about what the timing is for updates. And then the one other point that Mark pointed out, the consensus docs do provide for the contractor to be able to receive an equitable adjustment. The one caution that I would have with that kind of language from the perspective of owners, at least, is that any language which automatically entitles someone, whether it's the contractor, the architect, or whomever, to an equitable adjustment needs to be thought about. The reality in many projects is that if the project is running well and the parties have respect for one another, when issues come up, they face them, as Robbie mentioned a moment ago, forthrightly, and talk to one another about them, hammer out a solution, and reduce that to paper. Indicating that someone must get an equitable adjustment seems to imply, and at least in some states there's actually some case law that indicates that having agreed to an equitable adjustment, you must give an adjustment, and the only question is quantum, not whether or not an adjustment is appropriate in a given instance.
Just a couple of responses. I mean, I agree with Stan that both documents probably would require an additional scheduling, a more detailed scheduling specification, at least on any type of complex project. With regard to mention case law that owner approval of schedule could possibly mean the owner takes control of the schedule. I think any such case law would be in the minority. I mean, the owners groups have bought off on the consensus docs language. A lack of owner approval of the project schedule is just not a good practice. I mean, that was the consensus among the groups. The AIA requires, as we talked about before, AIA requires owner architect approval of the submittal schedule. Then when we get to the project schedule, we have this kind of wishy-washy language about for information only. The owner approval is a good practice, and it gives you an approved baseline from which to analyze the job and where it's going later on. And you know, this concept about, I agree, just because language says you might be entitled to a contract time adjustment, I think you got to read the contract as a whole. I mean, there are other provisions which show and deal with what the constructor has to prove in order to get a time extension or a cost adjustment.
With respect to means and methods, I think it's a truism that most people would regard the selection of construction means and methods, sequencing, scheduling, and other details as the preeminent right and obligation of the contractor or constructor, as referred to in the consensus docs. The owner and its design professional normally ought not try to dictate means and methods, and normally do not. The treatment of this subject within Consensus Docs 200 is pretty short and sweet. In section 3.1.2, the constructor's primary responsibility for the construction means, methods, techniques, sequences, and procedures is established, qualified only by the possibility that the contract documents give other specific instructions. In the case where the owner, through its contract documents, has attempted to specify or limit the contractor's or constructor's choice of construction means, methods, techniques, and sequences, under the Consensus Docs 200, the constructor is relieved from responsibility for the consequences of using those dictated means and methods unless it has actual knowledge that they have contained errors or inconsistencies or would bring about unsafe practices, and fails to report this knowledge to the owner and seek instructions. This is as it should be, since the contractor under section 3.11 of the Consensus Docs is given responsibility, overall responsibility for safety precautions and programs, and it is difficult for a contractor to carry out that responsibility, as well as many other responsibilities it has, including adherence to the schedule, as we just heard a discussion of, if it is not allowed to select its own construction means and methods. So the ConsensusDocs 200, in contrast with AIA to some extent, which I'll discuss a little bit, allows the contractor to exercise and requires the contractor to take responsibility for the selection of construction means and methods in the classic sense of construction.
The AIA 201, at least in the first instance, seems to replicate essentially the language of the ConsensusDocs 200. Section 3.3.1 says the same as ConsensusDocs 3.1.2 with a couple of additions. In the first instance, both documents say that the contractor, constructor, is responsible for construction means, methods, techniques, sequence, and procedures. The A201 goes a little bit further and says that the contractor also has control over, specifically has control over the construction means and methods. It then goes on to pick up a point that the ConsensusDocs address a little bit separately, where the 201 says that, again, the contractor is responsible for and has control over means and methods unless the contract documents give specific instructions. It gets to the point, again, about whether the owner or the architect is somehow intruding into construction means and methods. And I think this is part of a larger discussion about where the line should be drawn between design and construction, who has responsibility for what. It's theoretically easy to state that the architect has responsibility for design, the contractor has responsibility for construction, but in the field, where you draw that line or how you split the responsibilities can be a little bit difficult. The A201 goes on to say that if the documents do provide specific instructions about means and methods, reaching to Alex's point about safety concerns particularly, the contractor is to notify the owner and the architect if it has any objection to those means and methods from the standpoint of safety. The owner and architect are then to consider that, and if they choose to essentially override the contractor's concerns and direct the contractor to proceed notwithstanding its objection, then the owner becomes responsible for any damages that are result of the required means and methods, as opposed to summarily making the owner responsible for anything that may go wrong simply because the contract documents arguably specify means and methods. And again, I would point out that that distinction, although conceptually clear, can be a lot more muddied when you're talking about particular aspects of a particular project. The A201 goes on to state that the contractor must also, and this is the other side of the design construct dichotomy, must provide any design services that are necessary to carry out its means and methods, and ultimately has to provide licensed professionals with regard to any design work that is indeed necessary as a result of that. And then finally, and not surprisingly, since the American Institute of Architects created the A201, there's an explicit disclaimer about the architect's responsibility for means and methods. No such disclaimer for owners, however.
I think what Stan referred to there is what's been so far unspoken in this conversation about the architect and the AIA. We've talked about the primacy of the architect's role in construction under AIA contract documents. What we haven't talked about is the primacy of the architect's protection under AIA documents. And there's an interesting story about how the 2007 edition of this section 3.3.1 in A201 came to be the way it was. The previous drafts of this document or this language had said that if the contractor, which as we see now has an affirmative duty to study these means and methods, which it doesn't want to use, but the architect wants it to use, if the contractor objects to them and is directed to use them in any way, the prior language said the owner will be responsible, as the language in ConsensusDocs 200 said. Owner interests went to the AIA and said, what do you mean making us responsible? You know, it's the architect that prepares the documents which have required these means and methods. Why shouldn't the architect have some responsibility? And of course, rather than share the owner's responsibility in that fashion, the architect decided to share the owner's responsibility to some extent with the contractor, which had been required to use means and methods over its objection. And that was done by inserting the word solely into the last sentence of the provision in order to suggest that there's some sort of contributory negligence possibility here, or other shared responsibility, even where the contractor has done its absolute best to avoid using the unsafe means and methods required of it by the design professional. Not only in the A201, but also in the standard owner-architect agreement published by AIA, there is a very plain and unmistakable provision that the architect may not be held responsible for the contractor's means and methods. And as far as you can tell, that means even where, as in this situation, it has dictated them.
And I think Alec makes a good point here. The issue of where the responsibility lies is the question that could be multifaceted here. The first issue is, are we in fact dealing with means and methods, or are we dealing with something that is an aspect of design in the first instance? Again, my point is that dividing line between design and construction is not always as clear as some would like to presume it.
Okay, let's talk about the changes, provisions in ConsensusDocs 200. In 200, the constructor and the owner are to negotiate appropriate adjustments to contract price and contract time in good faith and as expeditiously as possible. There's these express requirements in the document. That type of express language is not in the AIA documents. A812, this first bullet there, also states that acceptance of the change order and any adjustments to contract price shall not be unreasonably withheld. Introduce the concept of reasonableness. So parties are expressly required to act in good faith and act reasonably in dealing with the change orders. Some of the other provisions in the changes clause, some of these provisions between the ConsensusDocs and the AIA don't differ all that much. Under the ConsensusDocs, there is one big difference, which we'll get to in a minute here, but ConsensusDoc provides for methods for adjusting the contract sum for both change orders and interim directed changes. An interim directed change under the ConsensusDocs is where the owner issues a written change prior to reaching agreement with the constructor on any adjustment. So the ConsensusDocs sets forth the ways of arriving at the method of adjustment, either through agreed unit prices, mutually accepted itemized lump sum, or cost of the work. The cost of the work provisions are quite detailed in the ConsensusDocs about what should be included in the cost of work, and the constructor must maintain records used to calculate the cost of work and make those available to the owner if they're going to price a change based on the cost of work. This provision here mandates that any change order shall include all outstanding interim directed changes upon which agreement had been reached since the last change order. That's not much of a difference there between the AIA provision. The main difference between the two documents deals with the situation where there is a dispute over whether or not a change has even occurred on the project. Whether, in other words, if the parties dispute that the owner action or direction is actually a change or an addition to the agreement. Under the consensus documents, it calls for basically a sharing of the risks in that regard. And what happens is if the constructor furnishes estimates of cost to perform, and if the owner then issues a written order to proceed and the constructor then performs, the owner is to pay 50% of that disputed work. But both parties reserve their rights under the disputes procedures as to whether the work was within the scope. In other words, and we'll talk about disputes procedures later in this presentation. But under the disputes procedures, if the owner prevails under the dispute resolution procedures, then the contractor would need to repay the amount that it got paid, the 50%, because that would mean the ruling was that it was within the scope of the agreement. If the contractor or the constructor prevails, then they will receive the full amount that they are entitled to for that change work. The consensus among the different groups was that this type of a system is far superior to the AIA, where the contractor essentially bears the entire risk of disputed work when there's a dispute over whether something is actual change to the contract. Here the parties share the risk initially until it is finally resolved under the dispute resolution procedures.
The AIA documents and the consensus documents, when it comes to changes, suffer from the same problem that every changes clause suffers from. In a perfect world, all changes would be fully negotiated, a written change order prepared and signed off and properly filed before the work ever began. We don't live in a perfect world, so we have to deal with the situation we find ourselves in. And so both of these clauses have some problems with them, but in reality there's not too much of a difference. One big difference is an approach, and that is the AIA approach is that changes will be either owner or architect driven. And that is that these AIA scheme does not, like the consensus docs, provide that the contractor can request a change order. It doesn't prohibit the contractor from requesting a change order, and certainly the contractor can assert a claim under other provisions. But the intent here under the AIA documents is that it's going to either be the owner or the architect that is making the initiative for the change order. And again, the contractor can certainly request a change, but there's no express provision allowing that. The AIA documents also make clear that eventually a change order is a document that is based on the agreement of all three parties, the owner, the contractor, and the architect. And I don't think that's necessarily a bad thing, especially if the change involves a design issue. If a problem later develops arising out of a design defect in because of a changed work, and the architect had not signed off, the architect might be able to argue that the owner and the contractor, through their change, altered the design, thereby relieving the contractor of any responsibility. I think I would like the architect in the change order process for that very purpose. Mark, if you could go to the next slide. As far as incorporating CCDs and interim change directives, and both the CCD process and the interim change process are the way of dealing with the fact that changes usually happen, that the work happens first and the paperwork follows later, and the CCD process and the interim directive change process are intended to address that problem, and they do it fairly well. And for all intents and purposes, this clause is similar. And Mark, if you could go to the next one. the AIA documents make clear that pending final agreement on any terms on a change, or whether there's a dispute as to work is extra work or not extra work, that the contract work should continue unabated. I think that's to the benefit of the entire project. It doesn't benefit necessarily the owner, the contractor, the architect. I think it benefits the project and keeps things moving. Lastly, the AIA documents do not have a specific formula for calculating what the contractor should be paid for disputed changes. But certainly, I think that the AIA documents provide that the contractor can request an interim payment, and that interim payment will be determined by the architect. I think under the AIA documents, it's fairly clear that if the owner directs work, extra work, that there is an expectation that the owner will be obligated to pay an interim payment pending final determination on the actual value of the change order.
Yeah, I think you're right about the interim payment, but I think that's a situation where there's at least an acknowledgement by the owner that there has been a change to the agreement. And the AIA, from what I read, does not really address the situation which is on the left side of this slide, where the owner just has simply refused to acknowledge a change, and I don't think it provides for interim payments in that circumstances. And that's why I think that the consensus docs really are much superior, and again, they were bought off by some of the owner groups that took part and have endorsed these agreements. And as far as the architect's involvement, I mean, that's a debatable point. I'm not sure. I know in all the cases I've had, you rarely get an architect who admits design errors, but I guess there might be some out there somewhere.
Let's move on to the subject of payments. Our slide shows 2 points about Consensus Docs 200. The second of which is really a pretty minor point. The differences are subtle and not critical between the constructor's or contractor's rights in the event of delayed payment, and mostly relate to the fact, as we've discussed before, that the architect is a central player in the payment process under the AIA A201. So the architect's certification is a necessary step in the protection of the contractor from delay in payment. But both provisions allow the contractor or constructor to protect itself by ceasing work in the event of unjustified delay or failure of payment. The more significant difference, in my opinion, between the two documents on payment has to do with the decisions to withhold payment, which are referred to in the AIA document as decisions to withhold certification and found in section 9.5.1. The corresponding provision of the Consensus Docs 200 is section 9.3. Under the AIA provision, which has been similar in versions of the A201 for a number of years, there are a variety of bases on which the architect may withhold certification of a payment which would otherwise appear to be earned by the contractor, some of which are probably completely uncontroversial and some of which are not. In particular, the AIA documents have always allowed the architect to withhold certification of a payment on grounds of certain causes which are purely speculative in terms of any damage to the owner. For example, subpart .2 of section 9.5.1 of the A201 allows withholding of payment to the contractor in the case of third-party claims filed or reasonable evidence indicating they will probably be filed unless security acceptable to the owner is provided by the contractor. Only here does the owner get to make the decision as to whether payment is going to be certified. And if it is insistent on not being satisfied or finding security acceptable, that will be a ground on which the architect will apparently be obligated to accept that judgment and withhold payment. Subpart .5 talks about withholding of payment to the contractor on grounds of damage to the owner or a separate contractor. It has never been clear to me why, if the contractor causes damage to somebody else, the owner must or should withhold payment to the contractor on account of it, without regard to whether it has any obligation to pay that damage. I know that during the revision of the AIA documents leading up to the 2007 edition, the AGC made several presentations to AIA about changes it would like to have made, and some of the requests for change had to do with these bases for withholding payment. It's particularly requested that AIA not permit the contractor's payment to be withheld on grounds of claims or damage if there was available insurance coverage to take care of them, so that the owner was not really exposed to any significant risk on account of those. These were deflected by AIA, but they appear now in the subparts to the ConsensusDocs 200, Section 9.3. The loss or damage is not a ground for withholding payment to the constructor by the owner if it has been accepted by the insurer providing builder's risk or other property insurance covering the project, which makes eminent good sense. The third-party claims involving the constructor or reasonable evidence that they are likely to be filed also do not provide grounds for withholding payment if the owner is provided with adequate security in the form of a bond or letter of credit or other collateral sufficient to discharge the claims. And another difference, finally, that is a beneficial one in my opinion, is the allowance to the owner or the architect to withhold payment where the constructor has not made payment to subcontractors or for labor, materials, or equipment is qualified under the ConsensusDocs in Section 9.3.3 to apply only where the owner has made payment to the constructor for the services, labor, materials, which the constructor has apparently or allegedly failed to make payment for.
I believe that with more and more jurisdictions enacting prompt payment laws, and the American subcontractors have been fairly successful in getting those enacted in many, many jurisdictions. I never thought I'd see it in either New York or New Jersey, and now both states have prompt payment laws. Terms in contracts providing for payment are becoming more and more irrelevant because they're going to be driven by statute. New York statute has gone so far as to allow a party who claims a violation of the prompt payment law to demand the dispute be resolved by expedited arbitration under the AAA rules, regardless of what the contract provides for dispute resolution. And the New York prompt payment law also provides that contract clauses that attempt to cut off the right to this arbitration are void and unenforceable. I'm not sure how one constitutionally takes away one's right to a jury trial, but that remains to be seen. That said, I think there are two important provisions in the AIA 201 that are not found in the ConsensusDocs, and those are the one providing that the contractor will not include in its payment application request for payment that contractor does not intend to pass downstream, and secondly, that the contractor warrants title for work covered in the application will pass to the owner. I think most contractors fully expect to do this and would not object to these provisions. As far as the right to withhold payment and remedies for non-payment, I think the documents are roughly equivalent. I would agree with Alec that the provision in the AIA document that the owner can withhold payment based on third-party claims filed or reasonable evidence are going to be filed unless there's some security, should make specific reference to the insurance provisions of the contract. And if the contractor has procured the required insurance covering third-party claims, there should be no reason for the owner to withhold payment. I think when it comes to payment that most contractors and owners understand or should understand that arbitrators and judges expect payments to be made when due. Contractors should only ask for amounts they are actually due, and only amounts that they can prove will be paid downstream and that they're ready to prove that the last payment was paid properly downstream. And owners should approach the payment process the same. Payment applications should be reviewed promptly, and everything due should be paid promptly.
I can certainly agree with that, Robbie. The other payment issue we wanted to talk about is retainage. And it's not quite as easy to make comparisons here because of the nature of the AIA documents as a two-part agreement. The A201, which we've been talking about, the general conditions of AIA, really doesn't govern how retainage works, as it doesn't govern a lot of the commercial terms of the contract. To see what AIA provides about retainage, one would need to look at the A101, which is the standard form of agreement. And it refers to retainage as a blank percentage which the parties should negotiate, and provides a blank where they may discuss, if they wish, reduction or limitation of retainage under certain circumstances. The ConsensusDocs 200, on the other hand, contains some beneficial provisions for the constructor and I think for the project, which are often negotiated anyway, but which are in this document standard provisions. The first is that the retainage will cease to be withheld when the project reaches 50% completion. At least where I live, the typical retainage provision is 10% at the outset of the job, and sometimes, often, where there's a sophisticated contractor negotiated to cease at 50% completion, so that at the conclusion there will be 5% withheld. But often that's debated by owners or their lenders. So in this provision, that favorable provision, which seeks, I think, to give the owner adequate security to protect itself early in the job, but not to allow over-withholding of retainage, is made standard. And it also gives the owner the option to reduce retainage at other times. And in section 9.2.4.3, the owner may, and probably usually should, release retainage on the work of early finishing subcontractors. This is a beneficial protection for the site work subcontractor, which is complete and long gone a year or a year and a half before the project reaches overall completion, and the retainage is otherwise released under the normal provisions of either the ConsensusDocs 200 or the A201.
I agree with Alec. I mean, retainage, why is retainage 10%, or why is it sometimes 10% and then reduced to 5% when 50% is completed? Go ask the fiddler on the roof. I mean, it's tradition. Probably if the bond has been provided, there should be no retainage. So I really don't agree with I disagree with anything Alex said about the retainage provision.
Okay, well, let's go on then to the final topic, and it's dispute resolution procedures. And both the ConsensusDocs and the AIA have a multi-step process for resolving disputes. And both agreements also require the parties to make certain choices about dispute resolution at the time that they enter into the contract itself. Under the ConsensusDocs, which I'll talk about now, the parties must attempt to mitigate the claims by communicating directly before an escalation of the claims. The way the process works, this first bullet here, is that parties' representatives who possess authority will meet and try to resolve the issues. I think that it's most likely that this would be the individuals at the site or the people who've been dealing with the contract on a day-to-day basis. Then if those individuals cannot resolve the dispute within 5 business days from that first discussion, it then moves on up to the senior executives, who and there's fairly strict time limitations in the consensus docs to make sure the process moves forward. And the senior executives shall meet within 5 days from those first failed discussions among the initial representatives. Then, if the dispute cannot be resolved by the senior executives, 15 days from that first discussion that we talked about on bullet 1 in the last section, then the parties will submit their dispute either to what the consensus documents refers to dispute mitigation or mediation. And this is where the parties need to make a choice at the time of contracting. If the parties desire it, they can choose what's known as dispute mitigation under 12.3, and you have two choices. You can choose a project neutral, or a dispute review board, typically 3 members. And if either one of those choices are made, the costs are shared equally. And the neutral and the DRB will make regular visits to the project. They'll have an understanding of the project and the type of work involved. And they must provide, once they are given, once a dispute is brought before the neutral or the DRB, they provide a non-binding finding or decision within 5 business days. And it's a non-binding decision, but the consensus documents provide that it can be introduced in a later adjudication if the parties do not accept the findings of the project neutral or the DRB. The AIA doesn't really have anything quite similar to that. I mean, that's fairly common in DRB agreements, that a DRB's decision would be introduced later in a later proceeding. But it is non-binding. Although non-binding, the idea is that the later trier of fact, either in litigation or arbitration, might be influenced by the fact that the parties chosen neutral ruled in a certain way. But it's up to the trier of fact later to determine the weight that he or she might give that non-binding decision. It's just another factor for the parties to consider and try to negotiate a settlement before they go down the road to binding dispute resolution. So to kind of recap, again, if the senior executives cannot resolve the matter, it either goes to mitigation, dispute mitigation, if the parties have chosen that. If they've not chosen dispute mitigation at the time of contracting, then if the senior executives cannot resolve it, it goes to mediation. And again, there's some tight time frames there. Mediation's to be convened within 30 business days of the very first discussion among the parties, and it's to conclude in 45 business days. And the parties can choose what mediation rules they want to apply. The default mechanism is the American Arbitration Association mediation rules. So you don't have to mediate if you have this project neutral or DRB, but if you don't, once the senior executives, if they fail to reach an agreement, it goes to mediation. Assuming that you cannot resolve it through mediation, or if the parties don't accept the DRBs or neutrals recommended decision, if they have that, dispute mitigation procedures, then it goes to binding dispute resolution. Again, this is where the parties, at the time of contracting, they must choose, at the time they sign it, they must choose whether they want litigation or arbitration. And venue is the location of the project. I think the main difference I see in binding dispute resolution procedures between these two agreements is this next to last bullet on the left. Attorney's fees and costs are borne by the non-prevailing party under the consensus docs. We have, so in other words, there's a prevailing party provision. Again, that's another check on the parties to help ensure that they don't take wholly unreasonable or outlandish positions completely through the disputes process, because there will be the threat of fees, and that threat of fees may help close the gap in negotiations. But there was a consensus among the different groups to include a prevailing party provision in the dispute resolution procedures, and so that is not the way, that is not, such a similar position is not in the AIA documents.
The AIA documents do have a different approach, at least at the outset. And I have to say, Personally, I like something like what the consensus documents have in the way of some means of getting the parties together to try to arrange for what I call a structured settlement process. I think that makes an awful lot of sense in a lot of ways. Having said that, I do have one caution that I just want to put on the table for people to consider when you're looking at the consensus docs approach by having the parties essentially sit down and try to work out a settlement and move it up the hierarchy if necessary. When you are talking in the context of a public project, there's a need to think about making clear how the process will develop and what, if any, rights are available under the process, because there are cases out there that indicate, not necessarily under the consensus docs, but under similar type provisions, sometimes in manuscript or customized documents, that when you have government officials involved on one side of the equation, there may be due process considerations. Do the fact that we have the government involved, does that require some sort of independent, impartial third party be brought into the mix as well? The case law seems to go all over the lot. I think the better decided cases are that this is intended to be an informal settlement negotiation, and that due process concerns don't arise at this point. But I at least want people to be aware of that as an issue when you're trying to adopt or adapt these documents to a public project. On the AIA side, of course, the big new item in the 2007 version of the 201 was the notion of this initial decision maker. Previously, the initial decision was made by the architect in all cases. Now, there are a number of concerns about that. Should the architect be making a decision about the rights of the contractor and the owner? The notion is that the architect is supposed to be impartial when it attempts to fill this role, which it still can, because in the event that the parties do not decide upon an initial decision maker other than the architect at the time they sign the owner-contractor contract, then the architect becomes the initial decision maker by default. So the concerns are, can the architect in fact be impartial? Should the architect be impartial? When for all other purposes, the architect is a representative of the owner, and of course, for all purposes, the architect gets paid by the owner. Is that fair to either side to expect the architect to attempt to be impartial given those facts? Which then raises the question of, should we use the initial decision maker language to adopt something like a project neutral or a DRB? Presumably you could. There's no obvious prohibition against that, but certainly you would also need to think through what other authority would need to be addressed in terms of some of the provisions that are in the consensus docs, and of course also negating the process excuse me, for the initial decision maker that is in the existing A201. And that process starts with the notion that the initial decision maker is to address only claims that involve the owner, unless all of the parties agree. So the initial decision maker is not to be taking on disputes between a contractor and a subcontractor unless the contractor and subcontractor agree, and then presumably the initial decision maker agrees to that expansion of its authority. Claims must be submitted in writing to the initial decision maker within 21 days of the event giving rise to the dispute, or when the first recognition of a dispute occurs, whichever is later. That time frame can be critical. A number of courts around the state are enforcing notice requirements much more stringently, and contractors are finding that what may otherwise be valid claims are being lost simply because the procedural aspects of a given contract are not carefully met. So I caution people to be alert to those provisions, and here it's the 21-day notice provision. Once the claim is submitted, the IDM has a couple of options which it is to perform within the next 10 days. It can request additional data from either party. It can simply reject the claim. It can, by the same token, summarily approve the claim. It can suggest that a compromise would be appropriate, or it can indicate that the initial decision maker is simply unable to resolve the claim. And this is sometimes used as an out clause if the architect is the IDM and there is an issue where the architect is involved and there's some question about whether it is proper for the architect to resolve the claim. He simply punt it, essentially. Another bit of authority granted to the initial decision maker is that in considering the claim, it's not uncommon, of course, these days for there to need to be expert testimony on some aspect of a claim, either an issue relating to the liability for the claim, the entitlement for the claim, or ultimately the quantum of the claim. And the IDM is specifically authorized to request that the owner provide and pay for an expert that the initial decision maker deems necessary. There is, of course, no obligation on the owner to actually provide that. Now, when we're dealing with the situation where the initial response by the IDM is to seek additional information, the A201 provides some rules for that eventuality as well. The first of which is that the information is to be provided within 10 days, or within that time period, the person who has been requested to provide additional information must indicate the time frame in which it will actually provide it. This, of course, can give rise to a certain amount of gamesmanship and possibly delay. Once, however, the information is provided, then, of course, the initial decision maker moves to consideration of approval or rejection of the claim. In any event, the IDM must produce a written decision, either approving the claim, rejecting the claim, or stating why it finds itself unable to resolve the claim. And this written initial decision under the A201 is a precondition to further proceedings in dispute resolution, the first of which is typically mediation, at least with regard to claims arising prior to the due date for final payment. There is an out here from the issue of the process taking too long, in that if the IDM has not ruled on the claim within 30 days after it received the claim, then the parties can proceed on the mediation. As a consequence, although there can be some concern about this process being held up, again, often the concern is expressed that if the architect is involved, if it's an issue of design liability, the architect will simply hold everything in abeyance while it can do so under the terms of the contract for no more than 30 days. Once we have met this precondition, either getting a written initial decision or the 30-day period has run, either party may file a request for mediation, or it can file a demand that the other party, the other side, submit a request for mediation. when we move to mediation under the A201, it is itself a condition to further proceedings in the way of binding dispute resolution. One point that you may need to consider here is the effect of local law on these mediation proceedings. Many states have statutes that can impact the mediation process. It's a common example is a statute that requires that the location of the mediation be at the project site or some other locality within the state that the parties agree upon. So one needs to not lose sight of the fact that although we are proceeding down a contract path and we will be looking at rules under which the arbitration, or sorry, the mediation will proceed, can't lose sight of the fact that there may be statutes that must be complied with as well as we move into this stage of the process. Under the A201, as has historically been true, you go to American Arbitration Association mediation unless there is an agreement by the parties to do something different. If there is a notion that the parties would like to do something different, I think most people strongly suggest that that should be written into the contract at the time the contract is negotiated and executed, for the simple fact that once a dispute has arisen, asking parties to agree on anything can become much more difficult. One of the quirks of the AIA 2007 is that it now provides that if you are going to AAA mediation, you will do so under the rules that were in effect on the date of the agreement, that is the owner-contractor agreement. Quite frankly, this does not make a lot of sense to me. I suppose one could argue that it is intended so that the parties know what the process is at the time they sign the contract and therefore are agreeing to that. But I find it hard to believe that the process changed so significantly that this makes a difference once they get to mediation, which of course is ultimately non-binding in any event. So it strikes me as somewhat odd. Further, I'd point out that the AAA rules that are currently in effect don't fully reflect this, at least with regard to mediation. To institute mediation under the A201, we need a written request that is submitted to the other party and to the AAA. Now, at the same time, you can also file for binding dispute resolution, but that binding dispute resolution, whether it's arbitration or litigation, will be stayed for 60 days or possibly more while the mediation proceeds. The AAA also provides that, the AIA 201 also provides that the mediation will occur at the project location unless otherwise agreed, and that the cost will be split between the parties. If mediation is unsuccessful in resolving all of the issues, the parties may proceed to arbitration or litigation as their form of binding dispute resolution, but that selection has to have been made in the owner-contractor agreement when that document was negotiated and executed. The 201 simply assumes that a choice had been made and proceeds from there. If the choice is arbitration, once again, you may need to account for local law on arbitration proceedings and also locations, but also don't lose sight of the fact that the Federal Arbitration Act may have something to say about that and may indeed supersede local law. In any event, an arbitration can be sought no earlier than a mediation request, and under the A201 no later than the period permitted by the statute of limitations for the types of claims involved. Further, it's expressly stated that the demand must assert all known claims, which I think is a useful provision to assure parties that they are dealing with everything in one sitting and are not going to be faced with multiple or sequential dispute resolution proceedings. And the AIA 201 does specifically provide for consolidation of multiple actions and joinder of other parties with their consent. The one point that Mark made that I would comment on is the notion of fees and costs being borne by the prevailing party. I'm not always convinced that it's easy to determine a prevailing party, particularly if you win some, you lose some. And further, in the context of an arbitration, there's always the concern of an arbitrator splitting the baby in half, and then you effectively leave to the arbitrator not only that decision, but the decision of who is ultimately the prevailing party. I recognize that there are certainly some arguments in favor of having such a provision. I'm not wholly convinced of their efficacy at this point in time.
Yeah, two quick comments. Oops, sorry.
Go ahead, Mark, if you had a comment, please.
Yeah, just a quick comment. Under the consensus documents, the mediation rules are the current mediation rules as of the time of mediation, so there's a little difference there. That's really all I wanted to say.
Thank you. Well, I want to do a quick poll of our participants here while we're waiting, or while I'm looking through, and we'll get some questions going. And the poll question is, which contract provisions, hearing all you've heard, generally do you prefer? So while the attendees are filling out that poll, our first question is open for anyone, and it says, doesn't AIA A201 in section 3.3.1 give the contractor some responsibility for owner-directed means, because the contractor would have to provide resultant damage from owner-directed means, is solely responsible for damage, in all caps, and sole responsibility is very hard, if not impossible, to prove in construction projects. A201 says, quote, owner shall be solely responsible for any loss or damage arising solely from those owner-required means, methods, techniques, sequences, or procedures. So doesn't the AIA A201 give the contractor some responsibility for owner-directed means? So they'd have to prove damages.
Yes, the answer is yes. That was, I understand, an effort by the architect to assuage the concern of the owner representatives who were concerned about being fully liable for means and methods required by the architects. So they inserted the word solely to make it apparently possible to try to smear some of that liability on the contractor, notwithstanding that it has, at this point, tried as hard as it can not to use the means and methods dictated by the architect. So the answer, I believe, to the questioner's question is yes. That creates potential liability on the contractor, and I believe that was intended.
Okay, great, thank you. And we're going to close the poll in just a second here. And our next question is for Stanley. What due process concerns were you referring to regarding dispute resolution with public entities?
The concerns that I've seen addressed in some of the case law are, first off, that there is a need for someone other than the project representatives of the government to serve or to be involved, that there may be a need for an additional party, perhaps an independent hearing officer of some sort, to be involved, and that any proceeding involving the government cannot proceed so informally without very clear language in the documents, so that what you are required to do is provide some sort of notice and an opportunity to be heard, and again, that opportunity to be heard may be required to be before an impartial hearing officer. There then spins off issues about that, well, if this is such a proceeding to which due process applies, do we have other issues such as rights of discovery, opportunities to subpoena witnesses, opportunities to cross-examine witnesses, and the like. Again, my basic feeling is that none of this is really intended or ultimately really helpful to the parties, because they're going to do those types of things if they proceed down the path to binding dispute resolution. And what they're losing here is the opportunity to negotiate some sort of settlement.
Wonderful. Well, that is all the questions that we have here as well, and we closed our poll, and it looks like almost 70% prefer the consensus docs. So I want to thank you, Alec, Mark, Robbie, and Stan, for a very informative presentation, and thank you to our participants for joining us today. We hope this webinar helped you learn about the differences between consensus docs and AIA standard contracts. Consensus docs are the only standard contracts written by 33 leading construction industry associations. Every document in the consensus docs family was crafted and reviewed by a team of professionals with combined hundreds of years of practical experience representing all stakeholder interests. Should you have any need for any additional information, please feel free to contact us either by email, visit our website, or give us a call on the toll-free number. And again, the PowerPoint and a link to the presentation will be emailed to all registrants, and that may take a day or two, but that will be forthcoming. Thank you again. This brings our program to a close. I hope you all have a wonderful afternoon.
Bye now.